Welcome to the webinar. Just letting some folks in from the waiting room. Give us a few moments and we will be getting started. Okay, welcome. This webinar is titled Divorce Foundation Series. It's a 101 guide to Washington State family law and what to expect. And I'll be joined here in just a moment by Michelle Dellino, who will be providing a lot of great information today about what to expect related to divorce and family law. Um, so the way that this is going to work is we're going to take some questions from those who are here and try to answer some questions in real time that you might have about family law topics. But Michelle's going to provide kind of a foundational set of information for everyone to take with them. And so we will answer as many questions as we can while we're here. And, you'll be able to leave here with a lot of great information today. My name is Melissa Rosenberg, and I'll just introduce myself briefly. I am actually a therapist here in Seattle, Washington, and one of my specialty areas is working with clients who are navigating the divorce and separation process at various stages. Some of my clients are early on trying to determine if divorce or separation is their path forward, or if they're looking at marriage repair and just kind of trying to unpack some of the emotions related to all of that. I work with clients through their emotionally complex family law cases, and also on the other end when we're looking at navigating the next chapter. But today I'm here as a moderator, so I'm going to be reviewing questions that get submitted and trying to pitch those to Michelle and make sure that we have this run as smoothly as possible. So there's a couple different ways that you can ask questions. Two ways on the Zoom screen. There's a Q&A option, so you can submit a question that way. It will default to putting your name next to the question. You can also choose to submit it as an anonymous attendee if you prefer. Or you can send it through the chat. And if you send it through the chat, then that'll just come to me and I'll look at the question and we'll try to pitch it as well. One thing about questions is that if it's too detailed or case specific to your situation, we're probably not going to be able to answer it, but we'll try to pull out the theme and the more general questions that you might like to ask. Okay, so that's where we will start. I will hand it over to Michelle now to introduce herself, and then we'll go ahead and get started.
Hi, I'm Michelle Dellino. I'm the owner and founding attorney of Dellino Family Law Group. We are a full-service family law firm that has offices in Seattle and Bellevue, and we actually help clients all over Washington State. I've been practicing family law for about 16 years, so that means I've seen literally every situation from crazy to calm. So anything that you've been going through is probably something that we've seen before. We have 15 family law attorneys and a full support team. We handle all kinds of family law. So important thing to start it with is to tell you that I'm an attorney, but I'm not your attorney. So anything I say today is not meant to be legal advice. It's simply information for you. If you have very detailed, specific questions or hypotheticals, we'll do our best to answer some of your questions, but mostly we'll be delivering content today. And if you do have very case-specific and fact-specific information, I would, encourage you to get a consultation. Does not have to be with me, with any experienced family law attorney to know what your options are. But this is a really great place for you to come, get some initial information, get an idea of those very foundations, which is why the webinar is called Divorce Foundations. So I'm going to go through the main issues in family law that you're going to want to know about. I'm going to go through what a divorce attorney does in family law. I'm going to go through what some things are for you to expect in your case. You might be in the very beginning where you're just thinking about divorce and you don't really know what that means, or you might be further along and already be in the middle of a case or thinking about filing a case. One thing for you to know is that most people think about divorce for, I think an average of 2 to 3 years is what the data shows before they take any action, before they talk to an attorney, sometimes before they even talk to friends and family about it. So if you're in the initial stages and you're not sure where to go, the takeaway here is you're not alone, and that's very common. And if you are heading down the path right now, the takeaway here is that knowledge is power, and being prepared and knowing what to expect is a really good place to be. So with that said, I'm going to start with some basics. Something for you to know and think about is just the fundamentals of Washington divorce. And those really are, who can file for divorce in Washington? Like, what are the requirements? What if you just moved here? What if you lived here the whole time and the other spouse moved away? So there's a residency requirement in any state. And that means, when can a court enter orders that tell you or your spouse what to do? You have to be a resident. One spouse must continue residing in Washington at the time of filing or must reside in Washington. Washington, unlike other states, doesn't have a minimum residency period. So your spouse could move here and file immediately. It doesn't mean that there's jurisdiction over you, but it does mean that the court can enter divorce orders if somebody's a resident. So we can talk about what that means in a minute. But anyway, residency requirement. Somebody has to move here and establish residency, get a driver's license, get a bank account, and not be a resident of another state. Or the other side of that coin is you guys live here and you're married. Somebody moves to another state, right? And you remain here or your spouse remains here. Well, Washington is still probably the right forum as well. So that's something for you to think about. If one spouse doesn't live in Washington, like let's say your spouse moves here, files for divorce, and you've never lived here, then there's not what's called jurisdiction over you. What does jurisdiction mean? You're going to hear that numerous times in divorce. Jurisdiction means the authority of the court to enter an order, like I said, that pertains to you. If you never lived in Washington and have no contacts in Washington with the state, financially or otherwise, court can't really enter an order telling you to do anything. So that's one thing to know. When it comes to kids, it's even more complicated. Jurisdiction is going to be where the kids lived for the last 6 months. Or if that doesn't apply and the kids haven't lived anywhere for the last 6 months consecutively, that's going to be something that comes up. Or if your kids are in Washington because there's an emergency and they haven't been here that long, the court still might be able to act. A number of factors. But anyway, residency requirement. One person has to be a resident of the state of Washington at the time of filing. What about the grounds for divorce? Can anybody file for divorce? Do you have to prove that somebody did something wrong? No. Washington is a no-fault state. It's very often I'll have a client and they'll say, I don't want a divorce. Nobody did anything wrong, or I don't want a divorce. Can I stop it? The answer is no. Anybody can get a divorce in Washington for any reason. There's no fault allocated, which means if somebody cheats on the other party, if somebody, commits acts of domestic violence or does something that somebody might think is fault-based, you don't have to prove that there's some kind of fault or harm to get a divorce. Anybody can get it. It also means you're not going to get more money because somebody acted like a jerk. So all that's really important for you to know. You can't stop a divorce because you don't think one should happen, and you can't get more money because somebody behaves badly. There's other instances where you could get more money, but it can't just be because somebody treated you poorly. There's also no emotional distress damages available in a divorce action in Washington either, and a lot of people don't like that, but it's important for you to know that up front. Okay. The only grounds for marriage in Washington is, these are the magic words, the marriage is irretrievably broken. That just means one party doesn't want it anymore. So the marriage is broken if both parties don't want it. So that's the magic words, marriage is irretrievably broken. You'll see that probably in your final divorce orders. What is the waiting period? How fast can you get a divorce in Washington? There is this 90-day waiting period after filing and service before a divorce can be finalized. That period is supposed to stand for a time for negotiation, or if you want, reconciliation. If there's disputes over custody, assets, or support, that process is going to take a lot longer. A 90-day divorce is really fast. Unless you had nothing, were hardly married, and there's literally nothing to decide on, or unless you totally agree on everything, which is pretty rare. 90 days is exceptionally fast for a divorce. A more realistic timeline for divorce in Washington, if you have anything to negotiate, even in a friendly divorce, is more likely going to be 6 to 9 months. If it's more contentious, maybe 9 to 18 months. It really depends on the court your case is in, how much you have to deal with. If you have custody issues, financial issues, we'll get into what those issues are shortly. That's going to determine how much needs to be unwound. And it doesn't even necessarily mean that you're going to be fighting about things in court. Sometimes there's just a lot of logistics and things that need to happen. And the fastest result is almost never the best result, because the fastest result is usually just taking what the other party wants. And that's probably not in your best interest. So anyway, 90 days is the fastest, but typically divorce takes a lot longer. I would tell you this too. Think of divorce as a marathon and not a sprint. It might be a divorce with multiple sprints within it, but it's a marathon. It's going to take you some time to get it done. So if you have that expectation early on, you're going to be far far less stressed over everything. What I tell people to do early on while you're preparing for divorce, the best way to really think about it is this. You're going to want to gather your resources. So what that means as far as gathering your resources is getting a variety of things together. One is going to be financial resources. You're going to want to get your finances in order. Do you have the money to pay for representation? Do you have the access to money to live on right now? Or is it an emergency situation where the other party has cut you off from resources and you need to find access to be able to pay your rent or get food to eat? Like, what is the situation? If you're planning, though, make sure you have access to resources. And if you have questions about that, that's something you could talk about with an attorney later. Second thing is gather emotional resources. Get your support network in order. So it's always advisable for you to try to keep your costs down in divorce, and how you do that and save the money from when you really need it is, this sounds kind of maybe not what you expect, but get a therapist. And the reason why is that a lot of the time people have a hard time emotionally processing a divorce, even if they want it, right? It's a major life event, it's a major life change. And working with a therapist is a really good idea, because then you're going to spend far less money processing the divorce and getting yourself in a place where you can engage in meaningful conversations with your legal team, and as opposed to taking hours of time at a much higher rate talking to us. And it's not like we don't want to help. We want to know everything that's going on, but I can't tell you how to process the grief, and I can't tell you how to explain it to your kids in a way that is going to make you feel good. So, the more that you can do that work, the more engaged you're going to be able to be in your case, and the better it's going to be. Melissa, do you want to talk about that? She has a specialty in helping people with life transitions, so she can opine on that better than I can.
Just to note how important it is to have, that outside support. It is, essential to be able to also have people in your personal life who are unconditionally supportive and there for you through all the things. But having that, dedicated and intentional space to really, tease through and unpack and kind of just process where you're at emotionally and some of the complications and intense emotions that come up in this process is, really, really, really valuable and important. I have a lot of clients when they're working with their attorneys, emotional material comes up. I mean, this is a really complex time of life. You're breaking, something that was intended to be forever. And that leaves, clients with lots of grief, various levels of grief, even when it's your idea, even when it's the best path, even when it's the right decision. There's often kind of unexpected levels of grief that come up for clients. And so really having a space to understand and process through all of that, I just can't underscore enough how important that is during this time.
Yeah, that's a really, really good point. You don't know what's going to come up. Washington divorce is a choose your own adventure as far as how things can go. So it's good for you to be prepared and have people on your team. That also extends to gathering other resources. You want to figure out who's close to you. Like, you're going to want to keep information kind of close to the vest in a divorce, especially if you don't know what's going to happen. So don't post about your divorce on social media. Don't write about it online. Don't do anything like that that could be used against you. And figure out who are the people that you're going to lean on and trust. Close friends and family members, totally fine to talk to them, but keep your circle small and figure out who that is, because you never know what's going to be said to another party. Also, don't put anything in writing, text message, emails that you wouldn't want a court to see. You have to assume, that anything can be used, and you might get angry. Everybody gets angry and stressed at some point, and sending that angry text message, or, something you really didn't mean to your spouse or soon to be ex-spouse, is probably something you're going to regret later, especially in a divorce. And we've all done it. So it's not like if you've already done that, don't lose sleep over it. Just don't do it again. So that's what I would say. You're also going to want to gather resources as far as other people that are going to be helpful to you during your divorce. So that could mean a financial advisor. Sometimes a CDFA, certified divorce financial analyst, might be brought in by your attorney to help you plan and figure out what to do as far as an asset division. Not in every case, but sometimes it's helpful. You might need other experts in your case to value accounts. You might need a business valuation if you own a business. You might need to value restricted stock units and how much are community property and how much are not. There's a number of things you're going to need to do. If you have children and you're in a high conflict custody situation, you might need a custody evaluator. So there's a lot of different things. You might need a real estate professional. You might need an appraiser, all kinds of things like that. And your attorney kind of serves as a hub to help connect you with the right professionals. But getting your own emotional support and team together is really important up front. So you're smart to be asking questions and doing that now. That's what I would recommend. There's four main issues in divorce. I can start talking about those. Are there any questions you want me to answer right now, Melissa?
No, not yet. I think just jump
Good.
into those would be great.
Perfect. All right. There's four main issues in divorce that we're going to cover. I'm going to tell you what they are, and then I'm going to talk about them. One is asset and debt division. That happens in absolutely every divorce. You're going to have to divide assets and debts. We'll get into that. Two is whether spousal maintenance is going to be an issue in your case. And if so, what does that look like? Spousal maintenance is the Washington term for alimony. A lot of people have heard the term alimony. In Washington, we call it spousal maintenance or spousal support. We have a lot more friendly terms for things. That leads me to the next thing, a parenting plan. In other states, that might be called a custody order. Okay. And in Washington, anything to do with child custody goes in a parenting plan. So parenting plan it basically tells you where your kids are going to live, what decisions are going to be made and who's going to make them, what the holidays are going to look like. So it's a number of things, parenting plan. And then the last major issue is child support. If you have kids, you're going to also have to figure out who's paying what for child support and to whom. So those are kind of the four main issues. There's other what I would call ancillary issues that come up. Right. And those can be things like who's going to pay attorney fees? Where's that money going to come from? Are there protection orders or restraining orders that are necessary either in the beginning or the end of the case? And everything else kind of fits under one of the umbrellas of the four things I talked about. So that's something to think about. We'll start by talking about assets and debts. Okay. Assets and debts. You might think, well, we don't really have anything. We don't have a lot. We just have a house and some debt. You still have something to divide. Or you might think we don't own a house, but you have something because if you have a job, you're making money. So there's all kinds of things that you probably don't realize you have to deal with. Let's talk about property and asset and debt division. So community property. You may have heard the term community property. If you haven't, you're going to hear it now. Washington is a community property and property state. What does that mean? Community property are basically assets and debts, both acquired during the marriage. From the time that you get married till the time that you actually separate, that is the community period. So everything that you earn or spend or anything in there is supposed to be community property. That could be a home, it can be a car, it can be your sofa, it can be your retirement account, it can be credit card debt, it's anything. Okay. So in Washington, once you know what it is, then you got to figure out, is there anything that's in that circle that doesn't belong in there? That can be things that are separate property. Separate property is not community property. Separate property is either what you own before marriage, for the most part, what you own or acquire after separation, or there can be some exceptions during the community period that I was going to tell you about. One are gifts. If somebody gifts you something during the marriage, let's say somebody gifts you a wristwatch during the marriage, just to you, it's a gift. That's not community property, that is separate property. You inherit money. Let's say your grandparent dies and you're left money and you put it in an account. You don't need anything else other than you got this money inherited. It was inherited by you alone and it's kept in your own account. That's separate property. Other kinds of separate property is if you own, like a really common one, an asset from before marriage, and then it earns you money during the marriage. So if you own a rental home before marriage, and then you're getting rental income during the marriage, that rental income is separate property. It's not community property, even though you're getting it during the marriage because it comes from a separate property source. So first you figure out what's separate, what's community, and then you figure out how to divide it. So a lot of people think of community property and they think that that means that everything gets divided 50-50. Not in Washington. We are not a 50-50 state. If you take nothing else away from this section, take it that it's not a given that your stuff will be divided equally. Not at all. What is our standard for division? In Washington, it's what's called a just and equitable standard. That is supposed to mean what is fair, but I promise you what you think is fair is not what your spouse is going to think is fair. So think about it as equitable, and then think about what informs what is equitable. Well, the Washington court looks at two main things. One is how long you were married. Is it a short-term, a mid-term, or a long-term marriage? And two, what is the financial situation of the parties? So that means how much money are you making? What's your income potential? What's your education look like? How are you financially going to be when you move on and you're no longer in a marriage? So how long you've been married and what's your financial situation? Those are the main things. Other things come into play as far as how many working years you have left in a long-term marriage, how old you are, if anybody has a disability, if anyone has serious medical issues, a lot of those other things factor in as well. But the main thing to know is that you are in a state that is not an automatic 50-50 state. You might both have an interest in everything, but how much is going to need to be decided. And that can be a big difference. One party might think, oh, everything should be divided equally. And the other party might think everything should be 75, 25 or 60, 40 or any number of other scenarios. And like I said, it's choose your own adventure. It depends. There's a certain guideline when you think about short-term, midterm, and long-term marriages. And when you think about somebody who's a breadwinner and somebody who's not, are your incomes fairly equal? Or did one person stay home and take care of the kids? All of these kinds of factors really matter when you think about divorce. Financially, what we look at as usually the financially disadvantaged spouse, if there's a big difference in incomes. Somebody that stayed home or somebody that hasn't been in the workforce, they're going to recover financially a lot slower than the person who makes most of the money. So that's the kind of thing that could be considered. Anyway, your range will vary here, but that's just the basics on community property. Separate property that's owned before the marriage typically remains with the original owner, or if it's acquired after the marriage, or if it's a gift or inheritance. However, in a long-term marriage, um, sometimes separate property can be divided, or perhaps more of the community can go to one party to account for the other party having more money. So those are things for you to know. So again, factors to consider about division: duration of the marriage, financial situation of each spouse, the story of the marriage, who made what contributions, who made what sacrifices, did somebody move for somebody else's job so they couldn't get their own career going, and future earning potential and age. Those are all factors to consider. I can move on now to talk about maintenance. Anything you want me to address first? You're on mute.
Sorry. It's pretty detailed, so let me try to parse it out. They're asking about asset distribution and marital agreements. Can asset distribution terms be included and executed through a postnup? Spouse is asking them to waive rights in asset distribution and has proposed a separation agreement. However, if they don't want to separate because they're concerned it might affect green card application, so wondering about doing it via a postnuptial agreement instead of separation agreement.
You need to get an attorney if you don't have one.
Yeah.
Um, I'll give you the basics on this. A postnuptial agreement or a separation contract without really separating are pretty much the same thing. What you're going to want to do is make sure the agreement's valid, make sure it covers the specifics of what you need, which is going to be how you're going to handle money while you're still married and what happens financially if you don't. I mean, yes, you can do that. There are plenty of people that, for whatever reasons, maybe it's immigration, maybe it's insurance, maybe it's a number of things, they're not wanting to finalize a divorce or legal separation. If that's the case, yes, you could seek a postnuptial agreement, or you could call it a separation contract. It's really essentially the same thing. It's something that's done after marriage that's going to dictate either how you're going to live separately but stay married, and how your estate is going to be divided, marital estate is going to be divided if you separate. So anyway, a number of things you can do, but the most important thing about that is to make sure it's comprehensive and to make sure it's valid. We do a lot of prenups and postnups and also cohabitation agreements, separation contracts. It doesn't do you any good unless it's actually valid. And I've done a number of seminars on that, and there's a whole lot of things that you need to do. So I'd recommend you get some legal advice and take a look at what kinds of terms you want to cover and how to make sure that works for you. So good question.
Mhm.
All right. Now, I'll take one more before I move on if there is one.
Yep. Okay, how are short, medium, and long-term marriage length of time defined? And is that length of time calculated including the time separated?
Yeah, that's a great question. Sure, let's talk about that. So I usually use a good segue because I talk about it in terms of spousal maintenance, which is our next topic. So short-term marriages and the definitions on these are they're defined in Washington case law, and there's actually an article in a legal scholar treatise a long time ago that really kind of formed the basis for this. So what I'm saying that is this isn't something that's a black letter law where this is this. It's not very firm. It's loosely defined. But typically 5 to 6 years or less is a short-term marriage. Nothing longer than that is going to be considered short-term. Mid-term marriage, which is really kind of the biggest bucket, is going to be, I would say, 6 to 7 years on up to 24 years. And there's different ranges of midterm marriage. I mean, you could have a 8-year marriage, that's midterm, but it's a pretty short midterm marriage. Or you could have a longer midterm marriage, which is, maybe 15 to 20 plus years. Okay. So that's a midterm marriage. A long-term marriage in Washington is specifically defined as 25 years or more. So that's the one thing that is defined. So you kind of know where midterm ends and long-term begins because there's specific case law, marriage of Rockwell and others that define what a long-term marriage is in Washington. And there's different ramifications for that. Also, something important for you to know that I'm not going to get really deep into today, but that is Washington's committed intimate relationship doctrine. There are entire webinars and articles on that I've done. So if you want to know more about that, that could be a big deal for you. What is a committed intimate relationship and why am I talking about it now? I'm talking about it now because it can expand potentially that community window. Here's a good example. Parties get married in 2020, getting divorced in 2025. Short-term marriage, right? Right. But parties lived together for 10 years before that continuously and were basically in a marriage-like relationship before they got married. There's the potential for all or some of that to be what's called a committed intimate relationship period. So maybe instead of just dividing these last 5 years, you could be dividing 15 years of assets. That's kind of scary, right? But it's true. I had a case a few years ago that went to a trial where the parties were literally married for 9 months, but they lived together for 12 years before that. So there was a lot to fight about. It was really like a 13-year asset division, not just the 1 year. However, continuous cohabitation, and again, I'm not going to go through all of the factors in committed intimate relationships. You just need to know that that exists. Living together with someone in Washington in a committed relationship can have different property rights attached, but it's not a guaranteed. Just because you live with someone before marriage, that entire period is a committed intimate relationship period. We've also seen many cases where a court will find that committed intimate relationship period was only a couple years, it was after you lived together a couple of years. Sometimes it's right from the beginning. It really depends on your situation. It's very fact specific. So anyway, when it begins is either marriage or potentially before. When it ends is separation. And that means, when your case is when you're separated. However, the duration of the marriage and what's considered. If you're separated for a year and you were married for 12 and then you're before the court, 13 years in, court's going to be looking at it like a 13-year marriage. They're going to know you were separated for 12, but it's still a midterm marriage, doesn't really make a difference. The whole amount is before the court. If you were married for 1 year and your case drug out for 2 more, so it's a 3-year situation, the court's going to be thinking of it pretty much still as a 1-year marriage, not a 3-year. And they're going to wonder why it was so high conflict. So it kind of is fact specific, but the marriage is over when the marriage is over, no matter how long you're married. So you could be separated. I had a case once where the parties were separated for, I think, almost 14 years before anybody filed for divorce, and they were married for 10 before that. I mean, it was still a 24-year marriage, but that was a really rare situation. But that being said, it wasn't treated like a long-term marriage necessarily the way it would have been, or almost long-term marriage. So it's a very fact-specific analysis, but I hope that helps you understand a little bit more. So spousal maintenance, short, mid, and long-term marriages. Why does that matter? Because spousal maintenance in Washington, we don't have a formula for it. We have guidelines, again, just like community property. It's not written in stone. There's different factors. There's a statute in Washington that talks about factors to consider when awarding maintenance, but how long? For how much? What does it mean, right? Well, every 3 or 4 years of marriage is kind of a general guideline to result in 1 year of maintenance. So that means in a 12-year marriage, you could get 3 to 4 years of spousal maintenance. In a 16-year marriage, maybe you're looking at 4 to almost 5.5 years. There's a range, right, of what's acceptable. That can change if there's extraordinary circumstances, or if someone's disabled, or, that period can be expanded, or it can be less. And it's not a given that you're going to get maintenance just because you're married that long. That's where it comes down to things like, what's the person's need? What's the other person's ability to pay? What was the standard of living during the marriage? Does that matter in a short-term marriage? No. Does it matter in most midterm marriages? No, unless there's kids. So there's a lot of different factors that can come into play for you to know. But in a short-term marriage, typically 5 or 6 years or less, there's typically not a lot of post-divorce maintenance. Why? Because the general principle in a short-term marriage is that people go back to where they started, right? They go back to where they started. Nobody's relied on the marriage long enough, to count on it for anything. Everybody should go back to where they started. So in a short-term marriage, it's very often, unless there's a huge discrepancy, people split the marital estate 50-50 and there's no maintenance. That's really common. Other times, in a longer short-term marriage, maybe 5 or 6 years, maybe there's a year of post-divorce support, maybe. depending on what the circumstances are, if there's a kid or anything like that. So short-term marriages, usually no maintenance, or maybe just temporary maintenance and a little post-divorce. Midterm marriages, the intent in those cases is different than a short-term marriage where you're backward looking. Midterm marriages, the whole idea here is to let parties become rehabilitated. So if you have a stay-at-home mom, which is really common, or a stay-at-home dad, I had one of those recently, and they've been home while the other party's, working, and they've raised the kids and they need to get back into the workforce. Maintenance is intended to help rehabilitate them to do that. And because when you've got kids in two homes, you certainly don't want one party living in a studio and the other party living in the house. You want some sense of like equality, right? So in a situation like that, maintenance, let's say you have a 16-year marriage and let's say you go with a 4-to-1 ratio, 4 years of maintenance. It might stay the same amount for the whole time, but very often it will decrease as a part of the case, because the idea is the other person will become self-sustaining at the end of it. Does it mean they're going to have to make as much as the other party? No, it just gives them some time to figure out what they're going to do. In a long-term marriage, there is case law that allows for lifestyle maintenance, which means the parties should be able to maintain the same lifestyles moving forward and should be largely equalized because they've relied on the community for a very long time, right? So short-term, backward-looking; midterm, rehabilitative, equalizing, and becoming self-sufficient; long-term, equalization, moving forward. 3 different principles. And they really matter when you think about spousal maintenance. How much maintenance? Again, that's a very fact-specific analysis. It's not the same in every case. It's going to depend on income, spending, debts, what someone's monthly budget looks like. You'll probably do a financial declaration before you figure that out. All kinds of things like that will need to happen. So that is a little bit about maintenance. Other things to know about maintenance: you might have heard me mention temporary and post-divorce maintenance. So temporary maintenance is maintenance that's paid to establish a status quo while the divorce is going on, because your case could go on for a year or more. It might or might not, but if it does and you're living separately and you don't have access to resources, you might need some temporary support. That's temporary support. Post-divorce support, which we were just talking about based on number of years, that's after your final order entered. So it's possible too in a short-term marriage that maybe you get some temporary maintenance but no post-divorce support. Again, it's all very fact specific, but that gives you a little bit of an idea of what to expect. So I hope that that helps. Before I move on to talk about parenting, anything you want me to address, Melissa?
Couple questions, yeah. One person's asking, you had mentioned, just for a spouse that's financially weaker, they just want to kind of clarify that person that might actually then get more than 50% of the common property once it's divided, right?
I mean, they should, unless it's a short-term marriage and their incomes are really close and their earning potential is really close. Yeah, I mean, disproportionate divisions are super common. And if somebody is what I would call a financially disadvantaged spouse, they're just getting back into the workforce, or your spouse makes 300,000 and you make 50,000, then yeah, you're gonna be in a situation where you're negotiating for more of the community, and that's what's equitable. That's the whole point of just and equitable. It's a good question.
And then another person's asking, if there are common disputes over asset division during divorce, even if there's a prenup. Are there things that come up when there's a prenup that people
Depends on
are?
how good your prenup is and if it's valid. I mean, I had a lot of cases with prenups, and I also draft them all the time. And the worst is when I get a prenup that everybody signed and everyone's like, "Oh, there's nothing to dispute," and I'm like, "Well, you didn't deal with this, this, and this." A good prenup will deal with almost everything financially, but some prenups will leave major issues out of the prenup. Who's going to pay attorney fees? Is there going to be spousal maintenance? If so, how much? What are the factors? All kinds of different things. If you have to value any accounts to divide them in line with the prenup, who's going to do the valuations? Who's going to pay for that? Who's going to decide if there's a discrepancy? How's the home going to be valued? I mean, all kinds of things. So your prenup might cover a lot of the rules of the road, but depending on how thorough it is and how forward-looking it was, people anticipating what your situation might be, I've seen a lot of really, really bad prenups that aren't comprehensive. So there often are still issues, but having a prenup and having a good prenup can eliminate a lot of those and keep your costs down in divorce. But yes, there are very often things that get thought about when there's a prenup because they're not contemplated in the prenup or they're not clear. So I hope that helps.
Mhm, mhm.
Okay.
Okay. Why don't you go into the next thing, and then there's some more questions.
Okay. I'll talk about parenting plans and custody. I think that's one of the other things. So the first two, property division and spousal maintenance, those are in every case. Even if there is no maintenance, you have to consider whether there's going to be. So those two are in every case. Obviously, if you don't have kids, the parenting doesn't apply to you. But if it does, parenting plan, you cannot get divorced in Washington with minor children without a parenting plan. You have to have one. Your case cannot be finalized. You can't just say, we'll figure it out later. It has to be done. So first thing to know, decisions in Washington parenting plans. Who decides what goes in there? The ideal is that you negotiate a parenting plan and you want to have an idea of what's reasonable. We, as attorneys, know what courts think is reasonable. We know what that's based on, and we know what's likely to happen if you go to court. So we're going to try to educate you on that, and you're going to try to hopefully negotiate something that makes sense and is in keeping with that. But what happens if you can't agree? Well, you might have a custody evaluation done. You probably have to if you guys can't agree and your custody case is somewhat contested. So what would happen there? You'd have a guardian ad litem, a parenting evaluator, you'd have family court services, or you'd have a court-appointed special advocates, any number of different ways you can get that evaluation done. And what are they going to be looking at? They're going to be looking at what a court's going to be looking at too, which is what is in the best interest of your children. Your parenting plan is about what's in their best interest, not what's best for you. And a lot of times people will be like, well, I need this to work with my schedule, or I need this or that. Nobody cares. It's about what the reality is and how that affects your kids. It's not about what's easier for you. So that's a real lens change for a lot of people who haven't thought about that. It's very child-centric. Parenting plans, and there's a number of factors that will be considered, but parenting plans outline residential schedules, which is where the kids are going to be when, a custody schedule, if you want to use the term custody, although we don't use that very often. Decision making, who's going to make decisions about extracurriculars, non-emergency medical, like braces or taking your child to therapy, who's going to decide, what sports your kid plays, who's going to decide any of those kinds of things. Those are extracurriculars. You can get really specific beyond extracurriculars, and you can get and non-emergency medical, and you can talk about things like social media usage, tattoos, when they're going to join ROTC as minors, all kinds of things. So, but the main categories are usually non-emergency medical, educational decisions, where your child's going to go to school and what educational decisions are going to be made, and extracurriculars. So medical, school, and education are the three main ones. Some people have a lot of others in there, but I tend to think less is more, and just covering the basics is really good, unless you have a high conflict situation where everything's going to be a problem. And sometimes you need more in those situations. So where the kids are going to live, who's going to make decisions. A good parenting plan won't just say who, it'll say how, and what happens if the parties don't agree, dispute resolution, how you deal with it if the parties don't agree. And the more specific you can be there, the better. So you're going to want to have really good language there. And it's also going to deal with things like transportation. If you guys are going to be exchanging, who's going to be responsible for the transportation? Where are the parents going to meet to do that? Is it going to be at school? Is it going to be elsewhere? The times for holidays, there'll be a holiday schedule. It's really clearly defined. There'll be a situation where you talk about a vacation schedule in the summer. Is the schedule the same in the school year as it is in the summer? Are there exceptions to that? All of those things are going to be in your parenting plan. It's also going to say, are there restrictions? Now, restrictions are generally not in a parenting plan unless there's a reason. And what are restrictions? It's a basis for one parent to have less time with the child or to not make decisions. In Washington, you might hear the term 191s. It's because there is a statute, and part of the statute is, it's Title 26, and the end of the statute is 191. So that lays out the different restrictions. Those can be for things like domestic violence, which right now is an automatic restriction if a parent has a finding of domestic violence. It can be substance abuse, where there's a nexus between that and parenting. It can be mental health if there's a nexus between that and parenting. It can be neglect. It can be abandonment. It can be abusive use of conflict, which is a more specific restriction. But there can be a variety of restrictions that are laid out in your parenting plan against one parent that can decrease that parent's residential time or decision making. So that's also going to be found in your plan. And if a parent has restrictions, or even if they don't, are parents required to do other things? Are they required to do any courses? Are they parenting courses? Are they required to do counseling? Are they required to finish this or that evaluation? All of those things too will be in a parenting plan. And how you get to those things is often through a custody evaluation or through the court. A lot of the time, your plan won't have any of that because you guys agreed on it through negotiation. So that would be a best case scenario for you. Courts favor right now frequent and continuing contact with both parents unless there's a risk for harm or unless there's restrictions. So when I started doing this work, it would very often be One parent would be the primary parent, and the other parent might have every other weekend. Then it kind of became one parent's the primary, every other weekend plus a midweek visit. Then it kind of became, oh, the weekend's no longer Friday to Sunday. Now it's Friday to Monday or Thursday to Monday. It became more time. Then, as things evolved, and a lot of the research behind it really evolved, and the studies and guidelines that courts and evaluators are looking at changed over time, it started to be realized that frequent and continuing contact with both parents is better, even if one parent was the primary parent during the marriage. So just because, one parent didn't do a lot of the parenting, if they're not a bad parent, they're still going to have a right to have time. So just because you always did things a certain way doesn't mean that's going to continue post-divorce. And that has really evolved over time. In Washington, there's also no presumption for either parent, which means some people will say, oh, this state is mom friendly or it favors moms or whatever, dads. That's not true. There's no presumption for the mother in Washington. Either parent is a good parent. The standard is what's in the best interest of your child as far as time. It has nothing to do with which parent is mom or dad, or if there's two moms or anything like that. So that's something for you to keep in mind. Okay, any questions about parenting or anything else before I move on?
Yeah, there's a few questions on the parenting topic. One person is asking, what happens if one person loses their job and accepts new employment in a state that's very far away? How might the parenting plan work in a situation like that?
Long distance parenting plans. Okay. So long distance parenting plans can come up two ways. One, during the divorce. Let's say one party's moving out of state for a job or to be back near family. That's one thing. The question is, do they want to take the children with them, or is just one parent going on their own? That's going to determine that whole situation. The other happens post-divorce, where somebody who has more than 45% of residential time wants to move out of a school district. If they want to move from Seattle to Bellevue, and they have more than 45% of the time, they have to file a notice of intent to relocate with the children. If they want to move from Seattle to Boston, they have to file that same notice. So it depends on when this is happening, and it depends on if there's already a parenting plan in place. If there is, the relocation statute is triggered if they have more than 45% of the time. If it's post-divorce and the person who has less than that is moving, they don't have to file a notice, but it's probably going to be the basis for a modification to a long-term plan. So modifications post-divorce are a whole other issue. It's very difficult to change a parenting plan once you have one. So that's why if somebody is thinking about moving, you're going to want to address that during the divorce, because if you don't, and then you have to move later, that's fine. I mean, that can come up and then it can trigger the relocation statute, or you could be seeking to modify the plan if the statute is not triggered. But it's difficult. And the reason why is courts favor stability for kids. Again, it goes back to that best interest standard. So once there's a parenting plan in place, you have to go through a process called a modification to change it, and that can be difficult. You have to show a substantial change in circumstances that didn't exist at the time, or that you couldn't have contemplated at the time the final plan was entered, to even warrant the court entertaining a modification. And then it needs to know what that substantial change is and what the basis is and what change you're asking for, and it goes down a whole other new case path. So you don't want to do that if you don't have to. You want to get a parenting plan that suits your needs. If you have a long distance need, so typically kids can't live in two places that are far away. Yes, kids can live in Seattle and Bellevue. That's fine. Kids can't live between Seattle and Idaho very easily, right? Regularly during the school year. So it depends on how far we're talking. It's even difficult during the school year for kids to live between Everett and Tacoma, right? Like it's not going to happen. They're not going to have a plan where both parents are taking the kid to the same school every day in Everett and Tacoma. So all of those things really depend. In a long distance plan, a very common situation, one parent, let's just say, moves to the Bay Area because they have a job there or they get transferred there. They are going to not be the primary residential parent if the kids are going to stay where they were before and stay in their schools, which is really common. Or if the kids are moving with that parent, that's a whole other thing. But let's just assume they're not. We have one parent in California, one parent in Seattle. The primary parent is going to have the kids all school year, right? The other parent might have a long weekend a month, and this is going to be case specific. They might have a long weekend a month. They might get all the 3-day weekends if they live somewhere like California or Oregon where it's easy for them to come up or the kids to go there. They might get all the long weekends, all the Memorial Days, all the Labor Days, all of those holidays, right? And then they're going to get more typically of the summer vacation time because they don't have that time during the year. So they're going to get more of the summer vacation time. They're going to get more of the longer school breaks. So they're going to get more of the vacation time because reality wise, there's just not a way to give them a lot of time during the year. And then they're probably going to get liberal long weekends, or they're going to get I like to put a provision in where if a parent lives out of town and they're going to be able to come in, they can give a certain amount of notice for an extra weekend if they're able to come. So there's ways that you can deal with it, but long distance parenting plans typically give one parent more vacation time than the other, obviously, and more break time because there's not another way to contemplate it. So I hope that helps. Anything else before I talk about child support?
Yeah, there's a few questions. In King County, you get a trial date about 11 months later as soon as you file for divorce. Are there cases where the trial might be delayed, leading to longer divorce process?
Almost every time your trial's going to be delayed. I hate to tell you that. But yeah, like, I don't know. I've been trying divorce cases for many years, and I can't think of more than a couple of cases where a case has gone to trial and gone out when it was supposed to. The reason why is this: two. One, courts are really busy, and family law cases, and the judges, even when you have cases that are on the family law rotation, those judges, family cases come after criminal cases. So if there's a criminal case and it needs to be heard, your assigned judge will get pulled to that first because there's constitutional rights implicated in a criminal case. Courts have to do things in a certain amount of time in a criminal case because someone's constitutional rights are violated otherwise. There's no constitutional rights to due process in a certain amount of time in a family law case. So cases with kids, here's another thing. Cases with kids are prioritized ahead of cases without kids because, and that's just the way it works. So criminal cases, and then there can be cases with kids and other civil cases, and then there's cases without kids. And cases without kids are the last priority because there's constitutional rights in criminal cases, and decisions typically need to be made in family cases with kids regarding school and all kinds of other things. So those cases go first. Even cases with kids, though, get continued. The reason why is, here's a secret. I don't know if you know this, but courts hate family law trials, right? They don't want to make a decision about where your kids live. They don't want to make a decision about who's getting what bank account or what freaking sofa. Also, don't bring your personal property complaints to court because that's the first way to make the court stop listening. They don't want to make those decisions. So there's every last possibility for you to work it out because there is a belief, which I believe is true, that most of the time you know what's better than somebody who gets to meet you for a couple of days and is never going to meet your kids. So anyway, because of that, there's a long case schedule. There's a lot of things that need to happen. There's a dispute resolution requirement that the court requires you to participate in before you ever go to trial. You have that trial date. It's not uncommon for your trial to be continued 2, 3, 4 times. I mean, is that going to happen in every case? No. Most cases are going to find a resolution before then. Your case schedule in King County will also have a deadline by which you need to seek a trial continuance. But I'm going to tell you what, I had a case that had gone on for a couple of years. It was very contentious, high asset, high conflict, and we had a trial date, and it was what we call a hard set, which most people don't get, which means it's not supposed to move again. But then the court got double booked and overscheduled, so they moved it on us at the last possible minute. And then it got moved one other time because then the judge was sick. So, I mean, like, you don't know what's going to happen. Most of the time, though, if a party seeks a trial continuance because they got new counsel, they need more time, there are issues with the discovery, it's going to be granted. So it would not be uncommon for your case to be continued, I don't know, a couple of times at least. So might not be what you want to hear, but it's really good that you asked because it's important for people to have realistic expectations on that as well. So I'm going to touch on child support really quickly so we hit all 4 issues and the basics, and then I'll take any questions in the final minutes that we have. So child support, unlike the asset division and the maintenance I talked about, actually uses a standardized formula. So what it will look at is the number of kids you have, the parent's income, and who's the primary parent, who has more nights, or are you on an equal schedule, and if so, are your incomes similar? So it's really important to know that we actually do have a formula for child support. It's crazy to say because you think child support, you think contention. It's kind of the easiest thing to work out. And it's usually the last thing that we work out in a divorce because it's just on the numbers, right? So payments basically continue from one party to the other, the non-residential or lesser residential parent to the other, until a child turns 18 or graduates from high school, whichever is later. And then at that point, a party can usually move for post-secondary support unless they've already decided that in a child support order to address, college education. Adjustments can be made every 24 months, basically just to update it on current income if you want to. Some people will never change their child support. Some people do it every 2 years like clockwork every time because they want to update on income. Or it can be changed at any time, again, like a parenting plan, only based on a showing of substantial change in circumstances that couldn't have been contemplated. Somebody loses a job and they've been trying and they can't get another one. Someone becomes disabled, that kind of a thing, can be a reason to change child support. What is child support? Child support is meant to cover food, clothing, basic life necessities. That's it, right? So gas you put in your car to drive your kid around, their lunches, their dinners, the roof over your head, all that is supposed to be covered by child support. Their clothes. It is not meant to cover out-of-pocket medical, educational expenses, extracurricular activities, or the big one that can add up when you have young kids, work-related childcare. Both parties will share in all of those what you will either hear as being called pro rata or proportional share. What does that mean? It means we do our worksheets, we get a number that each parent is supposed to be covering of the child support obligation. And then the parent who has less nights pays their portion to the other parent, right? Then there is a percentage based on what those numbers are. So let's say one parent makes 70% of the income, the other parent makes 30% of the income. So if your kid is going to play soccer, one parent will pay $70 and one parent will pay 30. That's what that means. You have a copay that's $20. One parent will pay 70%, the other parent will pay 30. So out-of-pocket expenses that are not basic life necessities need to be defined, and they're in your child support order. Who's going to cover the child on insurance will also be decided in your child support order. And sometimes parents will share the premium cost proportionally, again, along that proportional share, or sometimes one parent will just take a credit for it and build it into the worksheets. Depends on how you do it, but that's going to be set out in there as well. So anyway, child support, transfer payment covers basic life necessities, proportional share, division of the child support number along proportional share lines for everything that's out of pocket. Child support can be adjusted every 24 months by statute if you want to. Child support can be modified upon a substantial change in circumstances if that applies. Those are the basics. There's a lot more you can get into. Post-secondary support, I touched on that briefly. It's usually reserved in your child support order for later until that child knows what they're doing for college and is a lot older. You don't want to decide who's going to pay what when a child's 5 years old because you don't know what your financial situation is going to be and you know what their needs are going to be. So it's very common for that to be reserved in an order, unless your kids are basically almost college age when you're getting divorced, and then you're going to want to address those things so you don't run out of time or have to do it later and you kind of have a good idea of what's going on. So I hope that that is helpful. Those are your 4 basic issues, and those are your foundational issues to think about. I like to answer too for people, what does a divorce attorney do and do I need one? I think you do, even if you don't have anything. It's not just because I am one. I would never tell a friend or family member not to have at least some attorney consultation if you're going through a divorce. A divorce is the most complicated legal contract you're ever going to enter into, and you didn't have to do anything but have a big party and say I do, right? I mean, you didn't know. Maybe you entered into a prenup, then you knew, but most people don't do that their first time around. More and more people do though, and that's a whole issue for another day, which I think is good. But a divorce attorney plays a critical role in handling your divorce. They help you decide on asset division and let you know really what's in your best interest. Spousal support, custody issues, our responsibilities include legal representation, negotiation, and ensuring that your rights are protected. I hate it when I get somebody that went to like a DIY mediation and they're like, hey, I need an attorney to draft this. We agreed on a 50-50 division. And the person was, and they think that's great, but they don't know. And the person was a stay-at-home parent for all these years, and maybe they could have got 10% more. Well, if every, let's just say even 1% of the community is $10,000, and that's not even a super high asset divorce, that's $100,000 difference. I've had cases where people have come to me with agreements that they thought were fair, and it turns out they're probably leaving $500,000 or more on the table. You just don't know. So you should at least get eyes on what you're doing and consult with somebody and understand that you need somebody to protect your interests in undoing a legal contract. Like, I know a lot about taxes from doing this work. I know a lot about a lot of things, but I don't do my own taxes. I get somebody that's going to know the things that I don't know. So I recommend that you get advice somewhere, somehow. It's the best thing you can do. Getting information and coming here was also a good idea. I have about a few minutes. I can take maybe 2 or 3 questions because I talk fast.
Okay, sounds good. Okay, one question they're asking, if we privately sign a separation agreement between ourselves, would it have legal validity and enforceability? And if I wanted an attorney to review the agreement before signing, can you request that your spouse pay for that fee if they're the one who's the higher earner?
Don't be stupid and draft your own agreement. I'll tell you why. Very early in my career, I had a trial case where the whole trial case was about we drafted this and we both signed it and we're trying to say it's valid. One party said it was valid, the other party didn't. There were all kinds of experts, all kinds of things on this agreement 7 years later. It cost those parties about $150,000 to litigate it. You should spend a couple $1,000 and have the agreement drafted the right way and make sure that it's valid. Can you do a binding agreement without attorneys? Yeah, but there's definitely going to be questions about validity. Almost I can think of a handful of cases that have all been trial cases, and they've all involved people trying to DIY something. It's just too important. Yes, you could ask your spouse to pay for someone to review something, sure, but it doesn't mean they're going to. And if you have an attorney review something, they're probably going to say, "Here's all the changes you need to make. Let me redraft this for you," because you don't know. You might think ChatGPT knows. It doesn't know. It has a bunch of things in there that aren't specific to your state, that don't apply. Or you might take an agreement and run it through ChatGPT and have a bunch of questions and say, "Oh, what about all these things?" Someone did that to me not that long ago. And I'm like, well, you just wasted 2 hours of my time and yours that you paid for because you asked me questions that have nothing to do with anything. And ChatGPT doesn't know because it's not a person. So I highly recommend that you have somebody draft something that's going to be valid. It's like I said earlier about prenups. Separation contract is the same thing. It's even more important, actually.
Mhm. Okay, another question, it might be a little nuanced. They're talking about what happens if you have a child who is over 18, but due to disability, hasn't yet graduated from high school, probably still living at home. Can child support or parenting plan still be in play, in a situation like that?
No parenting plan can be in play for someone over 18. That would be a guardianship situation. You'd need to get a guardianship over an adult child to make decisions for them. No parenting plan is legally binding on someone over 18 because they're an adult. As far as support goes, you would want to address that potentially before you get divorced, if there's going to be any kind of agreement on post-divorce support through a post-secondary means. But if your child's already 18 and you're getting divorced, you're going to have to go through other ways outside of the divorce to deal with it.
And is that the case too? So disability doesn't matter in that situation, you
Well,
know?
no, they're an adult with disability. I
Yeah,
mean, they're adult getting their own. I mean, if they're getting disability, they're disabled. I mean, if they're already adults, there's no jurisdiction. And this comes back to that early thing I talked about, jurisdiction. The court doesn't have a right to enter an order requiring one parent to pay for an adult, like in a divorce.
yeah.
That's not a thing. You need to look at guardianship likely if your child's already 18 and disabled or getting their own disability. It's a whole other area. The court doesn't, even if they want to, they don't have the right. If you guys make an agreement on it under post-secondary and some of that child's needs, that's one thing. But this, yeah, that's again very fact specific. You need to
Yeah.
talk to an attorney.
Yeah. Okay, I think that kind of concludes most of our questions today. We were able to give out so much great information and we really appreciate everybody coming. When you ask questions and you put things out there, it really helps. Even if you don't have a question, others being able to, filter out questions and get things that you might have not thought to ask, but are interesting and good information to relay. We really appreciate everyone's participation.
Yeah, thanks for coming. I mean, even just being present and getting a chance to listen is a really good thing. If you didn't ask a question, if you did, I hope it was helpful. Next steps for you, I would highly recommend that you talk with an attorney. It doesn't have to be me or my office, just somebody that actually does family law. Don't talk to a general practice attorney or somebody does a bunch of different things. I promise you they don't speak the right language when it comes to family law. So anyway, good luck. Thanks for coming. Thanks for your questions and have a great day. Bye-bye.
Thanks, Michelle. I'm just going to leave the contact slide up here for a few more moments. If you are interested in contacting the law firm and scheduling a consultation, please reach out. If anyone's interested in counseling services, you're welcome to reach out to me as well. Thanks again for coming, and we'll have more webinars soon. We'll be in touch.